Reviewing the California Privacy Rights Act of 2020, also known as Proposition 24 or the CPRA. The CPRA will enter into effect on January 1st of 2023 and will bring about some key changes regarding personal information. This includes new categories of personal information, more consumer data rights, expanded contract requirements, new definitions for sharing, profiling, and service providers, the creation of the Consumer Protection Privacy Agency, new risk and cybersecurity requirements, and new profiling provisions. Exemptions will also be covered as a change from the status quo. Consumer rights changes will include the right for consumers to request corrections to inaccurate information. This also includes an extension of provisions for opt-out options with regard to the sale of their information to third parties. The CPRA will also enhance opt-out rights for sharing information regardless of monetary exchange. The CPRA has also updated the definition for sharing data. Consumers 16 and under will now be able to opt in to sale or sharing of their personal information. And exemption limits will now be adjusted regarding the sale and sharing of information. Sensitive personal information changes include a definition update that details all categories. The CPRA stipulates communication to consumers about the use of data that is collected, and it also provides consumers the right to limit use and disclosure of sensitive personal information, allowing consumers to opt out of sale or sharing. Service providers, contractors, and third parties have changes regarding contract requirements, including the requirement that businesses enter into an agreement to share information and grants businesses with the ability to supervise compliance with contract. Non-third parties have been given a new definition as contractors, and these contractors are beholden to strict requirements with using and sharing personal information. New service provider definitions and contract obligations include the addition that service providers are prohibited from selling or sharing personal information they receive with contracted business operations. The CPRA mandates a new state privacy agency to enforce the provisions of the California Consumer Privacy Act of 2018 and has authority to punish for noncompliance. This agency, the Consumer Protection Privacy Agency, would shift power from the California Attorney General to a governing board of 5 people appointed by the Governor, Speaker of the Assembly, Senate Rules Committee, and the Attorney General. Risk assessments and cybersecurity audit requirements change under the CPRA, requiring the Consumer Protection Privacy Agency to adopt regulations that mandate risk assessments and cybersecurity audits with regard to the storage and processing of personal information. A new definition of profiling will be established, and this definition will be used by the Attorney General to review and authorize regulation about profiling, including how and why information is used. Profiling means any form of automated processing of personal information to evaluate certain aspects relating to a person, and in particular to analyze or predict aspects concerning that person's performance at work, their economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. Data regulations won't apply to naturally collected data by employers in the course of job applications or employment dealings until January of 2023, and similar exemptions apply to B2B communications outlined in the California Consumer Privacy Act of 2018. This moratorium only partially applies to information outside of this context, as it will apply in January of 2022 with regard to personal information collected by a business.